I don't think that, so, I don't think there is a much need of giving any lecture on this issue also. So, Mr. Philip, with your permission, can it be an interactive session where everybody is open to speak and ask questions, and I can answer them to the best of my ability, or we can discuss whatever they want to
We
discuss.
can, because some participants have sent some questions in
Yes,
advance, that
yes,
can be elaborated immediately after the speech, because all
yes,
are.
absolutely fine, absolutely fine.
So you in between, if some members have some questions, of course, I hope the speaker will permit to raise the.
Absolutely not an issue. In fact, I would love to be more interactive with people because it's a two-way learning. It's not speech and all that. It's both ways learning. So,
But only to without any interruption, you if you can speak, that will be,
yes,
otherwise questions.
okay,
That's it.
fine, fine. So, as far as today's topic is concerned, that is the personal guarantor as well as the corporate guarantor to the corporate debtor. I think the law is very clear on this issue that both corporate guarantor as well as personal guarantor to the corporate debtor will be dealt by the same bench in which the corporate debtor resides. When I say bench, it doesn't mean with the same court of the bench. For example, there are 6 benches in Mumbai and there are 6 benches in Delhi. If the corporate debtor is within the jurisdiction of a particular bench, for that matter, for the convenience of understanding, we can take the example of a Bombay bench corporate debtor. The corporate guarantor will also be falling within the jurisdiction of that particular bench. It means the Bombay bench. The personal guarantor of the corporate debtor will also be falling within the ambit of that particular bench, irrespective of the place of residence of the corporate guarantor or the personal guarantor. Now, when we say bench, it doesn't necessarily mean that the same court of this bench means there are 6 benches in Mumbai, and if the corporate debtor is being dealt by bench one, there is every possibility that the corporate guarantor or the personal guarantor can be dealt by some other bench. Although people have made so many recommendations with respect to that the corporate debtor, corporate guarantor, as well as the personal guarantor, all should be dealt by the same court also. We had detailed discussions internally in NCLT when these questions were coming to us, and we took a conscious decision that it will not be mandatory for the bench to allocate the case of corporate debtor, corporate guarantor, and personal guarantor to the same bench. However, if there is any practical difficulty being faced by the corporate debtor, creditor, corporate guarantor, or personal guarantor, the provision of combining the cases in one bench, one court, can be invoked, and with the permission of the President NCLT, those can go to one court. So this is what about the adjudication of the personal guarantor, corporate guarantor, and the corporate debtor is concerned. One more issue comes with respect to the moratorium. Each Section 14 moratorium automatically applying to the personal guarantor under Section 96. The law is very clear on this issue that the moratorium under Section 14 governs the corporate debtor, not the personal guarantor. Personal guarantor is governed under Section 96, and both are two different sections which are in force for two different uh, debtors, personal guarantor as well as the corporate debtor. One more thing which comes in discussion so many times whether the moratorium with the personal guarantor is having the similar operation as the moratorium with the corporate debtor. The moratorium for the corporate debtor starts from the date of admission of the petition by NCLT. It has nothing to do with filing of the case. However, in case of personal guarantor, the interim moratorium starts from the date of filing of the uh, petition against the personal guarantor, and the interim moratorium will end on the date of admission or dismissal of the application against the personal guarantor. From the date of admission of the personal guarantor into the insolvency, the regular moratorium will start. Sometimes the issue of whether the personal guarantor and the corporate debtor can be uh, uh, proceeded simultaneously, or is there any preceding or succeeding relationship both of them have. The Honorable Supreme Court has clarified it that there is no preceding or succeeding relationship between the corporate debtor and the personal guarantor and the corporate debtor also, corporate guarantor also. So you see, we have to go for with the basics. Sometimes this question is asked when the corporate debtor is not proceeded with, how can the corporate guarantor can be proceeded with, or how can the personal guarantor can be proceeded with? You see, one has to be very clear with respect to the basics of this case. When we go to basics, 90% of our problems are solved then and there only. The problems start mounting up when we, sometimes overlook the basics. What is the basic of guarantee? Guarantee is given as an additional comfort to the creditor that in case the corporate debtor is unable to pay its dues, the dues can be recovered from the corporate guarantor or the personal guarantor. Now, the liability coexists. It is not that only guarantor will be proceeded against the guarantor. Creditor will be proceeding against the guarantor only after exhausting all his remedies against the corporate debtor. We have to go to the basics of the Contract Act, which makes it very clear that the liability of the guarantor and the borrower coexist. I think with this, I'll close my discussion from my side, and now the questions can be asked by the participants, whatever they want to ask. Thank you, Mr. Philip.
One question which I would like to ask is that there is a corporate guarantor from Kerala, and the company is situated at Chandigarh or Punjab.
Okay.
And the Kerala-based corporate guarantor will also be brought under the NCLT jurisdiction of Chandigarh.
Yes.
So in such,
Yes.
and some personal guarantees are there far and wide across the country. And how, if an order is passed, it can be executed?
No, the order will be passed by you see, it has been clearly decided that NCLT bench under which the corporate debtor falls
Yes.
will only be dealing with this corporate guarantor as well as the personal guarantor, irrespective of the residence or registered office of the corporate guarantor or the personal guarantor. This is very clear. If there is something not in agreement with this, please let me know.
Suppose the property is situated in Kerala, that has to be sold.
Yes.
And the NCLT bench at Chandigarh, how it will operate for selling the properties of the corporate guarantor in Kerala?
Mr. Philip, NCLT bench doesn't sell anything. It is the RP who is to act and take the orders of NCLT bench. Am I right in saying that or not?
Is it not possible to send it to the court for execution? A court situated in Kerala in this case
Yes.
for execution. And in such cases, whenever some issues are there in the execution process, whether the executing court or the adjudicating authority will deal with that matter, because RP has to apply for execution.
RP will be applying for execution. Execution will be done by the executing court. And there is nothing of that sort that the executing authority of that particular state will not be following the instructions of NCLT Chandigarh. Or they will be making a question, they will be raising a question that it should be NCLT Chennai or Bangalore or whatever place is. I don't think that any executive authority can raise this type of questions that NCLT Chandigarh doesn't have jurisdiction on.
Just like in winding up, it gets the all India jurisdiction.
NCLT has all India jurisdiction with respect to execution.
Execution.
Nobody stops that.
But it has to take the assistance of the
Local court.
Local court.
Certainly, yes. The assistance will be taken by the RP or the liquidator as the case may be. And in case they find any difficulty in that, they will have to approach the same NCLT from where the order has been passed.
It will be a laborious process if the person
But,
guarantees.
Mr. Philip, sometimes I understand that the practical difficulty is being faced by the person who is actually doing the work. But you see, with the larger things in mind, there has to be some processes which are evolved, and on those basis, the entire functioning of the court system. You see, if it was not done like this, there would have been possibilities where different jurisdictions and different NCLTs are dealing with the same case.
Yes.
There is also a question which is being raised as to how the right to recover is applicable for creditor against the corporate guarantor, personal guarantor, as well as the corporate debtor. Can he file cases against all of them? Yes, he can.
Yes. Or they
The-
can pick and choose also.
Huh?
Pick and choose also.
He can do whatever he wants to do because he is the master of his money.
Yes.
He is to be given this authority to collect his money back.
Yes. So ultimately, what remedy will be available to the guarantor if he loses the properties in that process? Can he make, because the guarantor's valuable right is the right against the properties of the corporate debtor, because
Absolutely, he has, but there are three situations where he can or cannot exercise his power of subrogation. Number one, if before the admission of the company into CRP, he has paid something as guarantor, whether it is a personal guarantor or corporate guarantor, they can always go against the corporate debtor for recovery of their money which they have paid as guarantor. If the CRP against the corporate debtor has already been initiated, they will be taken as the creditor of the company, and according to resolution plan, they will be uh, given the amount. If the resolution plan is already approved, their right also, completes their own. They can't go further.
so guarantors can become creditors of the company.
In any case, till the time resolution plan is not approved, they
Is
can.
any payment made by them as against the
Right.
liability of the corporate debtor to the
before
financial
admission,
creditor.
before admission of the company into CRP.
Thereafter, it will not be taken into consideration. Oh,
You see, if you go by basics, till the time resolution plan is not approved and liabilities are not extinguished
yes.
by the COC, their claim should be admitted by RBI, to the best of my mind.
So the guarantors must be very careful to make the payment before the admission of the this insolvency petition.
No, this is not in their hand. This is in the hands of the executing authority.
Because they cannot even participate in under section 29A
No, they
as
can't.
a yes. Otherwise, they could make the bid and come as a resolution applicant.
You are talking about the promoters and
Yes.
guarantors.
Because in most cases, the promoters and directors are the guarantors.
Are the guarantors. Yes. They don't. You see, Mr. Philip.
Yes.
Again, I'll repeat the sentence. We have to go to the basics.
Yes.
Basic is that why the guarantee was given. It's a basic question from my side.
Yes.
Why was the guarantee, either personal guarantee or corporate guarantee, was given to the creditor? Because the creditor wanted to have some more comfort. Is it all right or not?
Yes.
So, if he has availed that comfort from the personal guarantor or corporate guarantor, where is the issue which is pending that he should not have been proceeded with before even corporate debtor?
Suppose he raises money for a repayment of the debt actually due. And can the creditor say no? It's under resolution plan. So we will go by the resolution plan only. And
No,
whatever
he
left,
raises money in his personal capacity as guarantor, or the corporate guarantor,
yes,
or the
yes,
corporate debtor.
he may be borrowing from somewhere else to pay off
Okay.
this. Yes.
Okay. So where is the issue? The creditor must be happy to accept the
Yes.
payment. Where is the question of resolution plan? If he wants to discharge the liability by arranging loans from third parties and he himself want to pay as guarantor, who is
Yes.
the creditor who will say that I don't want to take the money from him? I am yet to see any creditor of that sort.
Yes.
Creditor is interested in collecting his money, no? Or something else.
But when there are multiple creditors and for withdrawal of that petition, you require 90% of the unlike in the yes,
You are talking about a case where COC has already been constituted.
yes,
There are multiple of creditors. He wanted to settle with the one creditor who has brought in section
exactly,
719
yes,
application,
yes,
and for rest of the time they want to say that okay, we will settle you later. Let us settle him first, who has brought us into insolvency. This is what you are trying to say.
yes. And I am not a guarantor to some other creditors. I am a guarantor only to the main creditor.
In
And
that, you see, again, Mr. Philip, I'll go to the basic. The guarantor has given guarantee to one creditor.
yes,
He wants to settle with him,
yes,
but the other creditors, why would they be interested in the settling of one creditor and voting for coming the company out of insolvency? They would not be interested. Where would he get 90%?
but I will be dragged along with the claim of other creditors also in that process.
Certainly, this is how it is. We are known by the company we have. If we are in good company, we are good. If we are in bad company, we are bad.
That's correct. Thank you for such.
That is how we choose our friends. No?
Yes. So it's a very risky affair to stand as a guarantor to a.
Certainly, giving a guarantee, either personal or corporate, for somebody else's loans. I remember my father. I was very young at that time, although I came to know about that time later. I was a child when he was not, he is no more. And I came to know about his saying later from my elder brothers. They said that you can, if you are interested to help somebody, pay for him if you really want to help him. But don't give guarantee to anybody.
Yes, yes, yes. That is correct. Never give guarantee to anybody.
Never give
Un-
guarantee to anybody. If you want to help somebody, pay whatever.
yes,
Because in that case, whatever payment you have made, your risk is certain and absolute up to that amount only what you have paid. But if you have given guarantee, your risk is unlimited.
yes.
Trying to some suggestions as
Your voice is not
addition.
very clear. Can you be slightly louder?
Sir, suddenly I am having had a throat infection. Suddenly I am prepared to. Sir, very good evening.
Not able to understand.
Brother November, I am not posing any question. I am not, because you are having had a live discussion. So that
Can you
as
be closer to your mic?
am I louder? Am I audible?
Jinan sir, your voice is breaking actually.
Okay, let me. I'm recording.
Chinan sir, we are not able to hear you properly. Are you
Okay, now.
traveling?
No, sir. I am on the laptop in my room.
Can you be slightly
Anyhow,
closer
now
to
it
the
is
mic because
my mic is working. So I am closer to my mouth. I am thinking I am audible, and I am my video also seen.
Video
Then I
is
will.
not seen. Video is not seen.
no, even video is not seen.
Oh my God! One second. Certainly, some external problem. I may
Voice is breaking, sir.
Yes, Mr. Philip, we can continue by the time Mr. Jinan can
Yes.
come.
And sir, can you uh, elaborate on certain questions raised by members? Some
Yes,
10
please,
questions
yes,
was.
please. I think first question was, would Section 14D or Section 96 of the IBC apply to personal guarantor of
Yes,
CD?
that has already been answered. I think so.
These are two operating two different spheres. Neither he can say that 14 should be applicable to me also, nor the creditor can say since 14 is applicable, it will be against this personal guarantor also, both ways. These are operating in two different spheres. Is it all right or something else is to be elaborated on this, Mr. Philip?
Suppose
Is it all
Sir, I
very
am.
good? The bird is coming somewhere.
Excuse me, I'm leaving. I'm leaving from laptop and I'm from mobile. Please wait.
Now you are audible, sir.
Okay. Now I am audible.
yes. Now you are audible.
Yes, sir.
Okay. Sorry for the trouble. Sir, certainly to have in a live because my laptop connectivity has some issues. Sir, only to add something which has been already been discussed by both of the enlightened member and the enlightened members and speaker. That actually Lalitha Kumar ji case, it has been settled that finality of insolvency proceeding mercy does not operate as discharge of um, guarantee liability under the contract of guarantee. So I feel that the contract of guarantee would provide whatever may be. So a personal guarantor may not be afraid of it. That is what I want to add, sir. That is all.
You see, Mr. Jinan, as far as the IBC proceedings are concerned, he cannot go ahead with that once the resolution plan is approved. However, the other remedies available to him in other forums, no bar on that until unless some order comes against him or in favor of him from that authority.
Sir, sir, that's only I add it. So only, sir, for live discussion, sir. I think that participant has to ask more questions.
Yes.
So only to add inspiration to them, I added. That's all. That's all, my sir. Proceed, sir.
Second question which came to me, Mr. Philip. First is all right. Shall we go ahead with second?
Yes, second.
Okay. Whether CIP can be initiated against two corporate guarantors simultaneously for the same set of default. This is the question. Yes.
Yes.
Mr. Philip, you see, my mind is very clear on this issue. That the person who has given guarantee, the creditor who has given extended sub facility to the corporate debtor, he would have been happy with the securities given by the corporate debtor if he would not have asked for any guarantor. Am I right in saying that or not? Now he took one personal guarantor, one corporate guarantor. Even that, with that, he was not satisfied. He took two corporate guarantees. Now tell us, you or me or anybody pays to somebody. We have primary security, we have guarantees, everything. Why should somebody stop me from going against anybody with whom I have taken a guarantee? Only thing is that the restriction with me as creditor should be that I should not be paid what is due to me more than that. If I am recovering it from X, Y, or Z, who are the guarantor or corporate debtor, from whom I recover first, that should be my choice, nobody else's. That is the basic principle.
But my feeling is that unfortunately the creditor's liability is not incorporated in IBC, because once the creditor gives a huge amount to a corporate debtor, he should see that his money is spent in the proper way. It is not siphoned off. Or
Yes.
um,
When we are talking about the creditor's liability,
yes.
necessarily you are talking about the public sector banks
Yes.
and financial institutions who never bothered as to where the money is going.
Yes.
What your question is?
Yes.
You see, that is the liability, that is the onerous liability on them. However, what is happening is, sitting in the benches, we were observing it for a long time, that the creditors are very happy after getting an order from NCLT, whatever it is. Whatever it is, they just keep it very beautifully tagged in the file that this is the NCLT order where we have got 94% haircut, only 6% has been received by us, and we all are very happy because everybody has abolished all his sins.
Yes.
Whatever those were. Everybody's sins have been, taken care of by NCLT order. Nobody bothered about the security of the asset, where the money is going by the corporate debtor, if it is against stock debtors and book debts, that is the CC limits. Nobody bothered whether there is a stock available. There are creditors. There can be fictitious stock. There can be fictitious debtors on the balance sheet of the company, whereas actually those are not realizable. For 3-4 years, you start increasing your current stock and start getting continue getting your limits enhanced. Then you start your increasing your debtors, and then your limits are increased. And then after, when you get into insolvency, there is nothing neither in the stock nor in the debtors.
Moreover, they indulge in restructuring the debt again and again, in spite of the fact that they know very well that it's not going to come back. And one fine morning, they declare it as a default and proceed against, and nothing will be left that time. And the poor
Mr.
guarantors who um, are left high and dry will have to suffer the burden.
Mr. Matthew, that is why 10 lakh crore were held up in the banking system in bad debts.
Yes. So it is mainly to clean the balance sheet, I think. The NCLT orders are being used.
Although unfortunate, but that is the thing.
And one more question which I am putting: what will be the future of these IBC proceedings? Looking at the past and the present trend.
Yes. Mr. Philip, to my mind, you see, this cleaning up process was required for the country, on which IBC has done a lot, and a lot is to be done by IBC in this regard. But you will appreciate that the lenders, particularly, now have become more cautious while lending. And that sense of discipline has come because of IBC only. You see, now we are getting lot of craving by the corporate debtors that bankers have become too much of strict in lending the money. Is it true or not? Now all those phone banking etc. have gone.
Yes.
Now people are more, you know, credit oriented whether they will be able to recover the money or not. And that is why, in addition to security, they are asking for corporate guarantees and personal guarantees of the people. You see, banking system since beginning, even whatever has been salvaged as on today, that is because of personal and corporate guarantees, not because of the secured assets of the corporate debtor. If bankers have taken personal guarantee, their house, the personal, the promoter and director's house is also taken on, as a collateral security. Only then bank is surviving. And the good banker always, calculates the risk and take the securities accordingly. Yes, please. Next question we can ask.
Yes. The third question with regard to the once the discharge has been made, what is left for the personal guarantor?
Nothing in IBC, outside IBC, under the Contract Act, under the against all other whatever the remedies available with him, those can continue, and will depend upon the order of the respected court on this regard. In
Means that
IBC, there is nothing after
nothing.
resolution.
So they can proceed as against co-guarantors if they want.
Who?
This one guarantor can proceed against co-guarantor if he has contributed more than his due under the
No, but how his due will be calculated?
because the creditor has proceeded against him and recovered the
No, but
whatever.
there is no divisible share among the co-guarantors. All were 100% liable for any money. There is no.
But
If you say co-guarantor,
yes,
was there anything of that sort there that he will be only one fourth
because,
liable, or
but
one
under
third?
146 of the Contract Act, they are liable to contribute equally. That was section 146 of the Contract
That's
Act.
fine. That's fine. Civil liability he can invoke, and it will depend
Uh,
upon the civil courts to decide
civil
on this. Nothing in IBC.
So IBC is mainly focusing on resolution of the corporate debtor.
That is
And
what that is what the basic is. You know, all other are stakeholders, not the corporate debtor. Corporate debtor is corporate debtor. There was one more question, whether the guarantee given by the managing director of the CD shall be treated as personal guarantee. You see, if he has given personal guarantee, it will be treated as personal guarantee. If he has guaranteed on the authorization of the corporate debtor that he is signing those documents, that cannot be a personal guarantee for him.
But the problem is that in some cases where a director has stood as guarantor and thereafter some disputes arose and that guarantor was ousted from the board and he has no control virtually on the board of the company. And in
Again,
such case,
again, I'll come back to the same answer. This is how we choose our friends, and our friends only will tell you in future that what type of friends they were.
because it happens many times. They start as friends, but in between they become enemies. And
But
someone,
Mr. Philip, you know what happens once somebody tries to allure you, no, you don't have to make any payment to the company, you don't have to subscribe for the director, become the managing director, I'll pay you XYZ, I'll pay you 10 times of what you are getting now. One gets allured and gives his personal guarantee, then whose bad decision was that?
Sir, may I ask you a question, sir? I am Josie Stephen.
Yes, yes. Yes.
My question is, currently, I think Anil Ambani has challenged Section 95 and 96, etc., because, without natural justice, appointing an RP also is biased, and, he was challenging that sections. So, in this condition, what is the, status of applications, admissions in various NCLTs? Are they blanket? I mean, there is a stay order, blanket order, or is it, it is case to case?
You say, as on today, the situation is that Honorable Supreme Court has not granted any stay. Number one.
Correct.
Number two, the petitions, many petitions, a bunch of petitions are pending with Honorable Supreme Court, for which hearing is yet continuing. Neither there is any stay by the Honorable Supreme Court in writing on proceeding against personal guarantor to the corporate debtor, nor any interim order has been passed in this regard by Honorable Supreme Court. However, the NCLTs across India have been informed by the councils that Honorable Supreme Court is seized of the matter, and till the time Honorable Supreme Court takes a decision, please keep these proceedings pending. And I think all the NCLTs now are not taking up any 95 section or 94 section matters of proceeding against personal guarantors. This is my information. If there is contrary to that, please let me know.
Sir, I have another question, which is a hypothetical.
Any NCLT, any bench of the NCLT has passed any order against personal guarantor?
I think in Kochi NCLT, we have bankruptcy already going on in one of the cases.
What is going on, that is going on, but no fresh case of admission or adjudication has been done by NCLT. Whatever has been done, that has been done, that is continuing.
Yes. Applications are being filed, but I
may interfere, Josie? One doubt clarification as regarding, as sir, you are speaking about the pending Supreme Court cases of Dilip B. Jewaji. Is it? Am I correct? Dilip B. Jewaji. Therein, where the constitutional validity of Chapter 3 is under question, I think there is no stay of the proceedings as such against the person there.
That is what I said, that there is no stay by the Honorable Supreme Court as yet.
Yes, sir. That's only for clarification. That is still pending.
There is no stay by Honorable Supreme Court, no interim order also.
Yes. This passes to
So,
Joshi, please.
See,
yes, sir.
I'll,
Sir, I have,
just
yes,
hold on.
another, yes, sir.
You know, so many times I am being confronted with a question that why there are delays in NCLT and NCLAT, or why there is, sometimes lot of confusion also on so many issues. I'll cite you 2, 3 examples. One is the balance sheet acknowledgement. It was very clear to everybody that balance sheet acknowledgement is an acknowledgement. This is the most reliable document of the corporate debtor if it is not forced or forced. You know, we all are aware, we all are practitioners in this field only. For 2 good years, balance sheet acknowledgement was not considered as acknowledgement by the NCLTs because of Honorable Supreme Court order. Now, again, the balance sheet acknowledgement is being considered as acknowledgement. You will find so many, issues which were held up not because of IBC. IBC is very clear on those issues. Companies Act is very clear on those issues. Because of judicial interventions, so many issues came up, kept the proceedings on hold in NCLT and NCLAT, and finally, either NCLAT or Honorable Supreme Court has decided the same thing which is written in the law, original law. It has happened in so many cases. Now, similar situation we are being confronted with respect to personal guarantor today. It is with Honorable Supreme Court, or the Honorable Supreme Court may decide the same way it is written in the IBC. There is a possibility that they may decide the same way. But in the process, the proceedings before NCLT and NCLAT are at hold. You know, this is the process of development of law. It's basically a new law, and the law is developed like this only through judicial pronouncements. And we all have to live with it, nothing else.
But the
Sir, I have another,
yes, go on,
Yes.
go on.
yes, sir. It's a hypothetical question which I may have. Imagine there is a corporate
But
debtor.
clarify, the question is hypothetical, answer will also be hypothetical.
Yes, sir, you are welcome. There is a CD which is under CARP,
Okay.
and there is a resolution plan. And as a part of the resolution plan, there is a provision that extinguishes the liability of the promoter guarantor. Okay, and a resolution plan is getting passed, but there is a dissenting financial creditor who doesn't agree with the resolution plan. Can he go against the personal guarantor?
Is it a hypothetical question or based on a particular question which is being considered by NCLAT agent today?
That I wouldn't know, sir. It was.
Go and check. This is a question which is being, under jurisdiction of NCLAT.
Okay.
The extinguishment of the liabilities of the personal guarantor by majority of the COC members, that is more than 66%, the dissenting financial creditor wants to continue with the personal guarantee of the corporate debtor. This is a question which is before NCLAT, and let us see what NCLAT decides about it.
Okay, sir.
One doubt which I would like to get clarified, that is, we do the acknowledgement of liability in the balance sheet. That is mainly meant for accounting purposes. But with regard to the filing of Section 7 petition, or even Section 9, the date of default is important. by mere acknowledgement of liability, the date of default doesn't get extended.
Yes.
And in such cases, Article 137 says the date of default, 3 years from the date of default. Because personal the financial creditors have got equitable mortgage, they under the relevant article they get 12 years time. But here in insolvency IBC they get only 3 years time. 3 years time starts from the date of default, not from the date of acknowledgement of liability. So how mere acknowledgement in the balance sheet will help them to
Mr.
file?
Philip, I will put this question in some other way before you, where you yourself will say that is not done what you are trying to say. You see, there is a bank, financial institution. The default was made by somebody in 1996. Okay,
Yes.
and after that, the case went to BIFR, AAFIR, DRT, Surface, everywhere it went. And finally, 2016, decree was passed in favor of the financial creditor. 2018, he came to IBC and filed a petition. Now, do you think that NCLT should admit it or dismiss it?
It should dismiss it.
If we do that, the entire banking and financial system will go to collapse. This is what the question which was in my mind when I was sitting in the bench. And at that time, the issue of this balance sheet acknowledgement was there when Supreme Court order was there that the balance sheet acknowledgement cannot be taken as balance sheet as the confirmation of liability, acknowledgement of that, and necessarily 3 years should be taken from the date of default. Can you believe? You see, as NCLT member or NCLT member, we are abide by the Honorable Supreme Court decision, and we have to follow it, come what may, whether it is wrong or right. Wrong we cannot say, right it is. Okay.
Yes.
Not even a single order which has been passed by me where I ignored that balance sheet acknowledgement and dismissed the petition. Finally, Honorable Supreme Court in that S. Shiv Kumar Canara Bank case, I think
Yes,
that
yes,
was
yes,
the
yes.
came back to the position where they said that balance sheet acknowledgement has to be agreed upon, approved. And after that, I continued passing orders against that.
Yes.
You see, sitting in the benches, we have to not only see the, although Honorable Supreme Court is saying, Honorable NCLT has said, NCLT is also operating in that way that the moment that is established, default is debt is due, default is made, and more than the threshold limit, the petition should be admitted. This is what it is. But tell us, there is a 1.5 crore rupees creditor. There is a 500 crore company, 500 employees working in that. Even if you establish that this company is in default and the case is admittable, I remember many cases where I gave them time of 15 days, either settle with the person
Yes.
or come with the solution, or we will be admitted. And in 90% of the cases, we were satisfied and we were successful in getting the matter resolved rather than putting the company into insolvency.
Yes, recently also said commercial solvency is not a factor to be considered into when admitting the petitions. Company may
Recently,
be commercially solvent, but if
no,
it
that's absolutely right. After this Vidarbha 2,
yes,
this has been made clear that don't have to look
yes,
into this commercial
commercial,
solvency, etc.
yes, yes,
If there is a default, you need to admit the petition.
yes,
But tell me, sitting in NCLT benches, fine, there is a debt, there is a default is more than 1 crore, you should admit the petition. You know, I'll share you my experience. I am basically from industry, and I know that industry is not to be stopped just for stopping. It has far-reaching impact. In sitting in Mumbai, we were dealing with a case where 5,000 employees were working, and if you take the family size of 4, 20,000 people were connected with that company, which was coming to us for insolvency, just for a default of 2.5 crore. Now, for me, passing an order of insolvency is not 5 minutes job. I could have passed it. The bench was very clear that there is a default, everything is there, and this case is admittable into insolvency. Still, we gave 7 days time to the corporate debtor. We told him very clearly the case is solid, and you are going to be into insolvency if you don't pay to them. Settle with them. After 7 days, they came settling the petition. Now, just by intervening for 7 days, the sky is not going to fall. This 14 days, 14 days, 14 days rather is not going to fall. And if you could save a company which is having 5,000 employees, 20,000 people connected, employees connected with it, and if you could save just by a small intervention, intelligence from the bench side, I don't find anything wrong has been done with that.
But this is mostly used as an arm twisting method to recover money from the
You see,
corporate.
that is why the adjudication is. What is the role of the adjudicating authority? The adjudicating authority has to see whether the amount is payable or not. If it is payable, then one has to be admitted into insolvency if you don't put this way, the way we have dealt with the cases. You know what will happen if we put them into insolvency? Immediately within 3 days, RP will issue the notification.
But on a larger perspective, if the company is a commercially solvent company, why there should be a resolution? If there may be so many debts, more than 1 crore, and they can go to the civil court, get a decree and execute it. Why they rush to the NCLT and file?
That is why the basic preamble of the IBC is shifted from debtors in control to creditors in control. That is the basic premise of IBC.
That means
You
you are
see,
taken out
you
of
are a
driver's
creditor.
seat.
No, you are a creditor.
Yes.
You have supplied some goods to the corporate debtor or provided some services to the corporate debtor. Is it not obligatory on the part of the corporate debtor to make you payment time? Is it not? This is the primary responsibility of the corporate debtor to pay for the goods he received or services he got from the corporate. Where is the question of delay?
But can the creditor come and say that if you don't pay, I will take you out from your driver's seats and put somebody there?
That is what the IBC is. The entire system of IBC is. Creditors in control. That is the basic principle of IBC.
But it is misused also.
You see, whenever there is a law, it will be used and misused. Now we have to see that whether in majority it is being used or majority it is being misused. If it is being used rightly in the right perspective, it will continue. If it is being misused, we are working in some democratic atmosphere where the checks and balances are always there.
Sir, I heard that some major amendments are going to be brought into the IBC, at least in
Yes,
the winter session of the Parliament.
on 18th January 2023, MCA brought a discussion paper on this, and they have done the consultation from all the stakeholders. The matter is pending for amendments with the Ministry of Corporate Affairs. What I have understood is that it may come up for discussion with the in the Parliament, maybe in the budget session or maybe after budget session, but not before that.
Next, that's a next budget session, not in the winter session.
To the best of my knowledge, it is not coming in winter session. But I am not aware about the, because this is the government which is to decide that how it is going to. But the latest information is that it is not coming in winter session. If it comes, nothing like that.
Yes, yes.
But I believe Ministry has already done its homework, and it is only the cabinet note and finally the amendment which are to be taken to the Parliament. Ministry has completed its job, I believe. Any other question somebody would like to ask?
Bijoy, any question? Mr. Ravichandra? Bijoy, please.
Participants, any more questions to be asked? May kindly ask right now.
Sir, can I?
Please introduce yourself, come on the screen and ask
Yes.
the question.
Yeah. Myself, Jason. Sir,
Yes, Justin Jose, I remember you. You used to appear before me.
yes, sir. Yes, sir.
You were looking after Kochi bench for some time. Yes, Justin.
Sir, once this Section 95 application is admitted, and initially this moratorium starts. So, what is the status of this? Guarantor with regard to operation of their banking accounts, as well as the other assets. Still, it is there in control.
You see, Mr. Jason, it has already been admitted, or it is interim moratorium is going on?
It is admitted.
It is admitted.
Yes.
You are RP there?
Yes.
Okay. Go by the book totally. My suggestion to you would be, because there is another person, regulator, who is just above you, and they are just trying to basically discipline the entire system. Go exactly by the book. Don't assume anything. This is my advice to you.
Yes.
I think it's enough, or something else is required.
No, sir. Thank you, sir. Thank you.
Strictly go by the book.
Yes, sir. Yes, sir.
Thank you, Jason sir. Is there any more questions to be asked?
Jinan Sahab,
Yes.
your expert comments.
Sir, I will comment, sir. I will comment, sir. Let the participants come forward, sir.
Yes. It's a good opportunity. I think participants should come out and can have some clarifications, if I can give.
Any questions?
Sir, I was operating the tribunal prior to amendment. During that period, the personal guarantor not directly subjected to the insolvency process. As you are in the introductory speech, you have already mentioned it. It is this law, the chapter 3, developed thereafter. And now I am confronting with the provisions. So I am equal to the lawyers and the personals who are participating before you, sir. And or enlightened questions which you are expecting.
You had greener pastures before this personal guarantor thing came into force.
Sir.
Vijay,
So,
do you have
yes.
any questions to be
Yes.
asked? Or else, like, we can...
No, I don't have any questions.
Okay, Jinan sir.
So quickly.
We are just moving on to Jinan sir. I'm just inviting him to propose vote of thanks. on behalf of NCLT Kochi Bar Association. Jinan sir, off to you.
Pass to me.
Yes, sir.
Yes, yes. Am I audible above? I am troubling
Yes,
you
sir.
all. Okay, okay, sir. I am operating from my mobile, so some limitations to me. Anyhow, respected President, Advocate Mr. Philip Matthew, our chief guest and resource person, honorable former member of NCLT, Rajesh Sharma ji, my brother member, office bearers of NCLT Kochi Bar Association, members and our beloved participants of this online seminar on the topic Insolvency against Personal Corporate Guarantees. Brothers and sisters, very good evening to you all. We NCLT Kochi Bar is aiming to provide latest and in-depth legal coverage to our members and professionals. This seminar is one among the programs we scheduled in a short span of time. The seminar was successful and come to end, and I am here to give a vote of thanks. Our chief guest and resource person, not to you all, our president gives us a picturesque view of the profile of Sri Rajesh Sharma ji, an outstanding scholar, having interest in academics, an active speaker of various national and international conferences. He had wide spectrum of exposure in central government, state government, public sector, and NCLT as a technical member. At present, he became a leading YouTuber, come with a novel project of talk show with insolvency veterans by sharing the inside story of outstanding judges of various High Court, NCLT, and NCLT. This talk show is getting momentum, even if he is on a tight schedule in conducting talk shows. Happily gave consent to be a speaker for us, and now he exposed his wisdom in the topic insolvency against personal and corporate guarantees, throwing light to certain gray areas pointed out during the discussions. On behalf of NCLT Kochi Bar Association, I extend my courteous thanks to you, sir. You also shared your presentation in advance to us for a live discussion on the subject, inclusive of a comparative study of personal guarantor with corporate insolvency. It would work too much for us, sir. Sir, I have no words to appreciate your effort in bringing this knowledge presentation in even writing to us. I take this opportunity to propose vote of thanks to our chief guest and resource person, Mr. Rajesh Sharma ji. We are really enlightened with your knowledge and presence. Thank you very much, sir. We are thankful to our respectful President, Mr. Philip Matthew, our Secretary, Bijoy Pilipara, for their motivation to organize this seminar. Thank you, sirs. I also would like to extend my special thanks to Sri Priya Harish and other office bearers of the association for their effort in making the seminar a success. I also would like to thanks to the participants who had an active participation and who have directly and indirectly contributed to this seminar on insolvency against personal corporate guarantees organized by our association. With these warm words and a kind message, we move to the end of today's seminar. Thank you, sir. Thank you all. Thank you.
Thank you, Sharmaji. Thank you for the valuable information shared with us, and we would look forward to seeing you again here. And also, we'll be participating in your talk shows also.
Yes. Thank you very much, and it will be my pleasure to be with you again, connecting with you again. But this time I will be coming personally rather than on this online.
Okay. Thank you. We hope to see you soon.
Thank you very much.
Thank you,
Thank
sir.
you, Mr. Anand. Thank you.
Thank you. Thank you, sir.